flurry. So I'm going to turn this over to Olof, and you can wrestle with this as we start to talk about the next things, and we'll ask Anthony for his questions. First question first.
Yeah, can you hear me?
Yeah, so Anthony has a question.
Anthony has a question. It's for Kurt, I suppose. Huh?
Yes.
Good.
Can you speak about batching and priority?
Well, we did a little bit yesterday, and we decided yesterday it wasn't precisely settled yet. But there's a preference for random batching, and the only semi-randomness to it would be that we'd want to take like strings that are in contention and take them together. So we do some sort of logical groupings there. But there's some, so frankly speaking, there's some legal issues associated with doing a random selection, and we're still evaluating whether that can be done just as cleanly as it can, or it has to be modified in some way.
Thank you.
Yeah.
Okay. Well, hello, everybody. And let's try to continue here in the middle of the process, or rather at the beginning of the process, where we have the initial evaluation. And there are a number of sub-steps, some of them occurring simultaneously, other preceding. In particular, there's a background screening, and that's quite important because the key individuals involved in the applicant will be screened regarding to involvement in crime and or cyber-squatting activities. So, and if that would be the case, well, it's call it a fail pass test. And that will be one of the first steps that are done. But let's have a look at the other ones. It's interesting. I push harder than Kurt and trying to get it quicker up. So the actual tests during the initial evaluation can be seen in two categories, one being sort of the reviews of the strings per se, and the other checking out the applicant. And the string reviews, those are all of a fail-pass nature. So if you string confusion, for example, all right, if you fail that, meaning that you're in a situation with confusion or identity with another applicant, well, then you end up in a contention set. If it would be that you're confusingly similar to a reserved name or an existing TLD, well, you fail completely. And there are also, well, the reserved names, that's a particular provision. So in that case, well, you cannot proceed. If it would be identical, it's already sorted out at the application stage. You wouldn't get to the initial evaluation if you had something that was identical to an existing TLD, for example. DNS stability, in the unlikely event that it's a particular string that would cause a problem with DNS stability. Well, one could imagine in the case of IDN strings, for example, where there are particular, for example, mixture of directions in it. Well, there may be such cases. There may be other, but of course there's a lot of pre-existing restrictions to what can be used in a string, and that will be checked here. And of course, geographical names, and we already mentioned that. Now over to the applicant. The applicant has to be able to run a registry. And, well, there are a number of technical aspects that will be checked, the technical ability, and also, of course, the operational and operational capability and financial capability. And the importance here is perhaps to highlight that it's a matter of the application being consistent. So whatever the foreseen development of the top-level domain in volumes and transactions and so, and the business plan and the financial projections that are made and the operational capability. They all must be seen from a holistic perspective. So there will be two panels dealing with this, but they will certainly exchange information on such matters, because it's quite clearly so that it's not a one-size-fits-all, and I think that has been mentioned over and over again. A big sort of aiming for global presence with multi-million domain names involved, and those perhaps being much more narrow cost, and brand applications being a case in point. Well, they cannot be measured with exactly the same yardsticks, but they have to be consistent within the application. And last but not least, in a minute, registry services. Well, in case there are particular registry services, sort of innovative ideas, there may be a need to go through what's called the R-step process, which is something that all registries existing are very well aware of, that a screening of whether a new proposed registry service meets all the conditions for stability and security, and also from a competition law perspective. So that's a test that is, I would say, the only one that entails an additional fee in this stage. Anthony, you had a question.
I do, thank you. I would be interested to know if you could speak to the standard that you're going to use about confusingly similar strings. For instance, NIC, Network Information Center, is a reserved string, but NYC is the name of the city. They would seem to be very, very similar in pronunciation and spelling, but clearly they're not the same, and they're probably unlikely to confuse anyone. So can you tell us about how you're going to judge these things?
First of all, I won't dive into the particular comparison here that you mentioned, but, well, it is, as was mentioned yesterday, a concept that's been inherited from intellectual property rights precedents. But of course it has to be adapted to particular circumstances. You don't have separate channels. In this case, the string similarity check is visual only. In initial evaluation, that is what is checked, whether they are visually confusingly similar. And you can think about it yourself. I mean, if you have a brand name, which is where the concept comes from, well, it appears isolated. In the case of a top-level domain, it would rarely really appear isolated. It would be at the end of a domain name or somewhere in the middle of a URL. And that changes the comparison parameters, I would say, to whether they're confusingly similar or not compared to the brand situation. So inherited from the brand sort of experience, but has to be then viewed in the particular context where the top-level domains operate. So, and the threshold will be high. It must be likely that there is confusion. It's not just association and, well, that a proximity on the keyboard or anything like that, but there is a visual, high likeliness of visual confusion for the average internet user. Welcome.
Mm-hmm. Ken has a question.
Oh yeah, Kurt.
No, Ken.
Oh, Ken.
Yes, Olof.
Please.
Yeah. Thank you.
It's always difficult questions. I want to interrupt him already.
I'd very
from
much
beginning.
appreciate if I could get some clarification here. At present, please, and maybe there's someone in the audience can clarify if it's something you don't feel comfortable with. At present, it's my understanding that the IDN process that is currently in place is, by definition, technically a testbed process. In other words, all of the IDNs that have gone into the root so far have gone in through as a testbed process. And it was my understanding that there had to be a clarification on that process before additional IDNs could be applied for, either by the CCTLDs that were originally offered the opportunity, but also by the general community. So I guess what I'm really asking for is some sort of reassurance by ICANN that at the point in time that the application process will open up, that the IDN applications would have the same treatment as the normal ASCII applications in terms of all of the issues surrounding clarification of the IDN string process. And I'm not just talking about single characters, but I know that there are various groups that are working on this right now, will be settled so that when you apply, you don't get into a situation where ICANN looks at you and says, thank you very much for your application, but we have additional clarification needed on the technical part of the IDN process, so we're going to put you aside for 3 or 6 months until we get this done. Are you at a point in time now where you have clarity from the technical community on the ability to put additional IDNs into the route without any problems from IANA or so forth? And I'm not talking about what you described as a little character going one way versus another, but thank you.
It's my understanding, and Kurt will correct me if I'm wrong, that, well, you have the conditions that you have to meet regarding the IDNs all lined up in the applicant guidebook. So there are particular carve-outs which, for example, coming to variants and things like that, yes, they cannot, well, must be handled in a particular manner and cannot be introduced in the road zone at this time. But for straightforward, within the parameters that are set, IDN applications, yes, they will be receive equal treatment to ASCII applications, with the little caveat that, of course, they have to fulfill the IDN requirements, which are specific, and they have to, for example, provide the IDN table. And the IDN table will be vetted also in this process. So I hope this at least answers half your question.
Yeah, the question, or the only caveat I would insert there is that you were talking about fulfilling the IDN requirements, which are specific. And you're really is ICANN saying that all the specificity will be in place at the point in time that the application process opens for IDNs. Because it was my understanding that there were still issues that needed to be clarified. But I'm sorry, I'm not a technician, so I really can't. I wish we had, if I'm wrong, please tell me.
There are study groups dealing with particular issues in various scripts ongoing right now. And they may inform the process, I believe. But for as far as I know, the carve-outs have been made so to make, the current conditions that you have to fulfill sufficient and to be certain that you can apply without any further ado. And
I don't want to say that.
well, he agrees. That's good. We had a little discussion. We had a two-person panel, and we scratched our head whether we should perhaps disagree.
Olof.
But we couldn't agree to disagree.
So, I agree with you. Let's keep going. We're running out of time.
Okay. Well, all right. Let's advance. Okay. So, what you enter into task is not sort of the final word, but consider it the final word from your side. There will be an opportunity. What's this now? Oh, I'm advancing this too far. Oh, yeah. doesn't really go back. Oh, it does go back, yeah. Oh, yeah. So, this is what I wanted to talk about, and this is the preceding slide, which I see here, which is rather confusing. They're not even confusingly similar. But you have the opportunity during initial evaluation. There may be an exchange through tasks with the evaluators if the evaluators see the need for it. And also, if you enter into extended evaluation, you have not only that, but there may be also an encounter with the evaluators. In order just to clarify, you cannot cure anything, but you can clarify what you already entered. So don't see this as, okay, let's just put in the application and we can fix it later. There are limited opportunities to do so. Now let's see here. Oh, yeah. All right, I think we already touched upon that one. But what happens if you don't pass the initial evaluation? The initial evaluation have a number of pass-fail individual questions. And also you need to score a sufficient, have a sufficient score, which means that you have to exceed the expectations explained in the applicant guidebook for certain of them. Now, if you fail, in certain respects, you have 2 weeks after you've been notified of that to file for an extended evaluation. Come on. Yeah. So, well, I already said that, didn't I? So, what happens is you can add material, but you cannot change what you already entered. You have to explain it in deeper detail, and the criteria would remain the same. It's no change in those. So, provided you passed the initial evaluation and the extended evaluation, well, what happens next? Well, you may be lucky and you go straight to delegation, approval and delegation, but there may be cases where you meet objection. An objection can be launched by various entities on 4 specific grounds. Kurt already mentioned which they are. And the providers for these services, the dispute resolution service providers, have already been appointed for these 4 grounds. So you've got string confusion, that the string would cause confusion with, for example, an existing gTLD, CCTLD, or fast track that already could claim that this is too similar to what we already got. So please lodge an objection for that with the dispute resolution service provider, and that's ICC in that case. And legal rights, of course, that's the venue for the rights holders, finding that, this is too close to our particular brand, and we lodge an objection, in that case with WIPO, who is the appointed dispute resolution service provider for that one. Limited public interest, well, this is avenue for example, the governments to claim that, well, this is in contradiction to international law, and the independent objector could also lodge such a claim, and that is handled by ICC as well. And finally, community. If there is a community that finds that, all right, there is an application with a string that's very, very, very close to the string that we need and we want to have protected, they can lodge an objection with NCDR. It's NCDR, isn't it? Yeah, for community objections. Also, and it's already been mentioned that the GAC, the Governmental Advisory Committee, they have a particular avenue to not only provide early warnings, which can be cured, for example, if it's an early warning concerning a geographical name, and the applicant can get the comfort letter or non-opposition letter from the government. That can happen. But a GAC advice, as it's an advisory committee to the board of ICANN, they can provide advice on a particular application that this, according to the GAC, has, with GAC consensus, is contrary to sensitivities that have been identified. A recent such opinion with GAC consensus will be seen by the board as a high presumption of denial of the string. So, with the objection, of course, the objection filing period starts as soon as the strings are announced, those that fulfill the completeness criteria, and the objection window closes 2 weeks, a couple of weeks after the announcement of all those that have passed the initial evaluation, and extend which, in order for those that want to object, not to have to spend the money to object in order if the application actually fails. And dispute resolution, well, we had the previous timeline, which was rather like, okay, in the good cases, we can have a 9-month baby from beginning to end, but it could be an elephant pregnancy as well if you enter into this and in the subsequent. So, well, the steps to follow, that we have the formal objection, and just repeating what we said earlier, the 4 objection grounds, and of course the applicant may file a response to the objection. It would be strange if it couldn't. And then the dispute resolution service provider convenes an expert panel and comes with a final determination of the case. The advice of governments, well, they have the early warning system, which is concurring with the public comment period, which is for 60 days. And that can be provided to, or is immediately provided to the applicant. It's not a veto at this point in time. It is just an advice, early warning from one of the governments that this, for example, it is a geographical name for which you should have, and you don't have the requisite support letter. And the applicant has the opportunity on getting in discussions with that particular government and sort it out. There may be other reasons for comments as well, which may be less easy to resolve, of course. Yep.
Thank you. On your previous slide, you showed an objection period of 7 months, but you said you have 2 weeks to file an objection. Could you talk about the difference? Or was that a typo, or?
No. It was rather an explanation. You have plenty of time. You have all the time from the announcement of the strings up until 2 weeks after the declaration of the initial evaluation. So you have 2 weeks extra. And that was a change that was introduced in order to bring some comfort to those that want to object, but they wouldn't like to spend the money if the application in question already failed during the evaluation. So that's, thanks for helping me to clarify what I expressed very vaguely. And then finally, the Governmental Advisory Committee advice to the board, and that can be a lot longer in the making, and it's directed to the board, and it could be, well, a high presumption that it should be denied in case of consensus. It can be more of an advice which is not supported by consensus, and then it's really up for the board consideration. And in both cases, of course, up to the board to consider those and take the appropriate action. Now, all right, you made all of that, and still there is something that needs to be sorted out at the very end. Because if a string contention situation has occurred between various applicants, and it could be a contention set that's pretty complex, can be unimaginably complex, well, it can only be resolved after all the other steps have been concluded for all those involved in that particular contention set. For obvious reasons, because some applications may disappear, and that may change the structure of the contention set completely, perhaps even resolve the contention. So that's at the very end of it. And two or more have identical or confusingly similar strings. And they may be chained in rather interesting molecular structures, if you want to dive into that. And that calls for a string contention resolution, and the steps for that, well, those involved in contention sets will be aware of that already from the early stage when the strings are announced. But they will also have the opportunity to reach an agreement with the other contenders for the string during all the process up until we have string contention resolution. And that's really the preferred solution. Preferred solution is agreement of the parties. It's number two. It should really be number one on this slide, but that is what we hope will occur. And that cannot happen by just agreement between the applicants. One or the other will have to withdraw and find some kind of solution of coexistence for the future through other means. Anyway, that's the preferred solution, and if that doesn't occur, and there is at least one community applicant that's involved in a contention set, that applicant has the opportunity of requesting a community priority evaluation, which is then an evaluation based on the nature of the TLD and the nature of the community. So, with 4 criteria for each community establishment, it has to be established well before the end of the policy development process that led to the proposal of having a community priority. There should be a good nexus between the proposed string and the community. It should bring the community to, the string itself should bring the community to mind at the very least, or be identical to the name of the community. Registration policies that clearly show that this is focused for the community and nothing else. And also a community endorsement by the established structures within the community, if there are more than one. And also taken into account any community opposition that may occur. Each of those could give a score of 4 points. And in order to get community priority and effectively knock out the others in the contention set, those in direct contention, you need to score 14 out of 16. That is one way of solving it. and that's the second step. But, all right, there may be cases where there are no community involvement, no community applicant, and there may be residual contention sets, and there may be cases where the community applicant doesn't score high enough, and then the final solution is an auction mechanism, which then would be the mechanism of last resort, but it's sure to make the final solution. And we can go into more details about the auction mechanism, because it's a very clever one, but perhaps we should change back to Kurt now and see for
Wrap it up.
to wrap it up a bit.
So I just wanted to make a point about agreement of the parties as a way to resolve. Thanks, Olof. You're terrific.
Ah, you are. Come on.
As a way to resolve contention, you know, we had a great presentation this morning about .hiv, and when asked the question, that gentleman answered, well, we'd want to talk to them and resolve it because we think we're after the same thing. It's a great answer. I was also given a briefing on new gTLDs to a trade association here in Europe, and the issue of their brother in the United States applying for the same name, and one of those gentlemen said, oh, I know those guys, we'll go talk to them, we'll work it out, don't worry. So I see great opportunity for parties acting in good faith to work these differences out. Anthony?
Yes, I'd like to ask a question about the evaluators, if I may.
Yep.
The technical part of the application has many, many multi-part questions, which are all graded pass-fail, or you can score 2 points in some cases. I'd like to sort of understand how the evaluators are going to go about that. I think it's perfectly possible that there's going to be very, very good applications that, for some reason or other, fail to answer one part of one question in, in a multi-part question, but are otherwise perfectly good. I know there is one mechanism so people can go back and the evaluators can go back and ask, but I'm trying to understand what are the criteria, how strict are people going to look at this? Is this going to be scored in the way that an RFP would be scored, where if you miss a point you're out, and it's looking for very strict adherence? Can you speak about that a little bit?
A little bit. The identity of the evaluators is going to be made public very shortly, and there's a considerable work going on with the evaluation managers to ensure that there's a consistency put to all the evaluations. And like I said earlier, the whole process is supposed to be a roadmap, and the questions, because there's different business models, the questions are written broadly, and the criteria for answering those questions is written broadly too. So the evaluators are instructed to look for the good in each of the answers, and where they're questioning where that good is, there's that opportunity for iteration. So there's not meant to be stops put, instructions given to evaluators that are essentially blocks or stops to the evaluation.
Thank you. I have one other quick question. With regard to government objections, it seems to me possible that you could have contending parties for the same string, and the government could object to one but not the other, basically objecting to the applicant and not to the string. Do I understand that correctly?
I think that governments could find strings objectionable for a variety of reasons that due to their national sensitivities and right to an application. So a government could react to an application negatively too. So that could happen. So really briefly, because I know we're out of time, once approved. Should I go ahead, or you want to ask your question?
To my knowledge, the consensus requirement for GAC advice has been removed in the latest version of the guidebook. Can you elaborate a little bit on the consequences? Would that mean that an objection from one individual GAC member could eventually lead to a process for an individual string to be blocked?
Right. So my understanding of the present agreement is that the GAC will, the Government Advisory Committee, will indicate that there's consensus as defined by the Government Advisory Committee. They're defining how they arrive at consensus. There's consensus that an application should not be passed, that that string should not be delegated. So that requirement remains. What was redacted from the guidebook was language that the GAC, the Governmental Advisory Committee, thought was prescriptive on ICANN's part. In other words, that they felt that the language we had put in the guidebook were more or less instructing the GAC how to go about arriving at consensus. And so they're going to tell us what their words are and how they're going to arrive at consensus. And we were just, out of a courtesy to the Governmental Advisory Committee, taking the words out that seemed prescriptive to them. But the requirement that the GAC arrive at a consensus that a string not be delegated, as far as triggering certain considerations by the Board of Directors, remains. So nothing's changed. Is that clear? Because sometimes I start sentences and I don't know where they're going, and now that I've rehearsed, I could answer the question a lot better. After an application has passed the evaluation, it will transition to delegation. There are three things that have to happen. One is that the registry will enter into an agreement with ICANN, and that agreement's posted as part of the guidebook in Module 5. Two is there's a set of pre-delegation testing, so at this stage of the game, some hardware needs to be in place and it needs to be integrated. And then finally, it'll enter into the IANA delegation process where that TLD string and the associated information will be entered into the root zone. So just a couple notes on timing and then we'll be done. Maybe. So some key dates are here. So we've already talked about most of these, or they were inherent in the slides, but we intend to publish the list of applications around May 1st. Initial evaluation will start in June. Might secretly start sooner, but so we get ahead of the game. But evaluation will start in June. The application comment period closes on June 30th, 2 months after the applications are posted. And it's planned that on November 12th, the initial evaluations are done and the results are posted. So then, depending on the outcome, that TLD application will start transition to delegation or enter into extended evaluation or some form of extended evaluation, either consideration of an objection or the contention resolution process or the redo of the initial evaluation. 2 weeks after the initial evaluation is over and the results are published is the last day to file an objection, so you can ready an objection and not file it until you know that application is passed to kind of save your effort. And here's some other projected dates and closing of string contention. So more information is available here, just like yesterday. Elaine? Well, I called on Elaine. Microphone person.
Thanks. This is an easy question. First of all, thank you so much. It's so nice to see a timeline with real dates. Yay. But I am wondering if this slideshow is available. I couldn't find it online on the new domains or the ICANN website yesterday. Do you have... will this slideshow be published?
Certainly the information in that slide will be published. It can be published on the ICANN website. I don't know with the conference organizers if they're planning to publish all the slides that are given here or not. Yeah. Tina?
Well, it's nice to win over my former CEO. So, my name is Tina Dam. I'm with myTLD.com. I just want to make a clarification question, if I may. Sorry to bring it back up again. But when you had the conversation with Ken about IDNs, I think I heard Olof say that IDN tables are going to be vetted by ICANN. And I just want to make sure that ICANN is not planning on something new in terms of vetting the content of the tables. You're merely doing like comparisons and checking that they're in the right format and stuff like that, right?
So that's correct.
Okay, good. Can I do one more thing?
Sure.
So Ken was asking about the fast track and the review of the fast track that has the IDN CCTLDs in it, and how that feeds into the policy development that's going on with the CCNSO for future IDN CCTLDs. And I know there's like annual reviews and all of that stuff, but am I correct in assuming, and I don't know if that's what Ken was asking, but that's what I heard. Am I correct in assuming that that's not going to affect the new gTLD program? In other words, those are kind of like parallel processes that go not hand in hand, but you know, it won't, unless it's like something that's technical stability, it won't affect the new gTLD program in terms of IDN TLD applicants.
That's right. That's right. One won't stop the other.
Cool.
Thanks, Tina.
Paul Toomey, I used to work with Tina Dam. First of all, Kurt, can I just say to you and to Olof, particularly to you, thank you so much from the community for all the incredible work you've done in this area. I know more than most how much you've been committed to this. Well done. It's been a phenomenal service. Round of applause, everybody. And I have a clarification question.
Yeah.
Remind me, if you put a deadline up there for objections or comments on an application, is there a deadline also for people to be able to respond to those objections? Community puts up X, somebody responds against community. Yep. Does community get a chance to respond to the objection before it's considered by
so there's a couple ways to answer that question. Are you asking in the case of a community-based TLD, or are you just asking in general that?
Well, I'm just asking generally because you had a timetable there of people putting objections or comments, and is there any opportunity? Is there a timetable for when the comments can be responded to by the applicant?
Yeah, and I think the best way to work that is that the evaluators have access to all the comments when they're doing their evaluation. And if there is a comment that would actually cause the evaluator to change the scoring on a question, it will ask the applicant for clarification on that comment. So that way, there's an opportunity to respond to comments in cases where it's really meaningful. But otherwise, if the evaluator is going to pass that application, then there's not a lot of need for response to comment.
Paul, I think also for the objection process, there will be, okay, for any objection that's lodged by an objector to a dispute resolution service provider. The dispute resolution service provider would notify the applicant, and the applicant would have a limited time, I think 2 weeks or something, to respond to that objection before the RSP makes the final determination.
This all may be moot, it may be too late on the timing, but you may want to consider opportunities for people to give responses publicly, or else you might generate media wars that you don't want to generate. So I can imagine circumstances, A puts forward something, B says X, A wants to be able to say, no, look, B is not relevant for the following reason. You don't let them have that chance to do so, then you're going to have that fight in the media. It's not going to be it's just about the integrity of the process.
That's a good point. Yes?
Hi. With the geographic domains, you'd mentioned that it would be the government's approval that you would need. So two quick ones here. One is that is it the government's approval or an endorsement of a particular company or organization that can apply, or is it that particular government that has to apply in their own capacity? And secondly, when you look at the city names, for example, and look at Indian example, and there's plenty around where basically there's a center and state structure as far as the government is concerned, and there are state governments and central governments. And most of the cities outside Delhi come under as one or the other state. So in that case, when you say government, are you referring to the federal government of the country or the state, or does it go down to, let's say, even the mayor of that city, or take a New York example?
So the answer to your first question is any entity can apply for any TLD string. So if it's classified as a geographical name, that entity needs the approval of the government, but it doesn't have to be a government applying. And in the case of your second question, it depends on the TLD applied for, what's the relevant government and what the government wants. So in the case of a capital city name, or eventually a country name, when they're delegated, it would be the national government. In the case of a sub-regional name, it would probably be the government of that sub-region, like the state. But certainly ICANN is not going to trump the wishes of a government who decides that it should be another governmental entity approving. So there's some discretion provided to each individual jurisdiction. We're out of time.
Hi. 3 minutes. Hi, Jose Rasco from Strat Investments. I just had a question regarding string confusion and comparison to CCTLDs. If you're considering visible or visual confusion with CCTLDs, does that eliminate most 3-letter or 3-character gTLDs? Because as you know, all CCTLDs are 2 letters. If you add 1 letter, it's going to be in common with most or many CCTLDs. Is that considered confusing?
Well, I don't know if you would consider a 3-letter string confusingly similar to a 2-letter string. That's I don't know, not anticipated.
Okay.
Let's put it like this. They've been in friendly coexistence for quite some time now, 2-letter and 3-letter strings as TLDs. And, doesn't that answer the question?
Much better answer than mine. Thanks, Olof. Ken?
Yes, maybe you can give me some clarification here. If I recall, the ISO 3166 designations had both 2-letter as well as 3-letter designations for each country. So would an application for a TLD string be considered to be a conflict immediately because there are existing ISO designators that are identical to that string, or have they decided that as far as they're concerned, the 3-letter designators are not necessarily, because they're not in general use, conflicting?
Yeah, so my recollection is, and go read the guidebook and test it, that the ISO 3-letter strings are meaningful representations of countries, and so they won't be delegated. And actually, one of the potential applicants changed, after that rule changed their application to accommodate it. So I think that's it. I'll turn the conference back over. And on behalf of Olof and I and everyone at ICANN, thanks very much.
Thank you very much, Olof and Kurt, for that very detailed explanation. You were great Sherpas, and clearly there were a lot of questions in the audience, so I think you satisfied a real hunger for information there. Many, many thanks to both of you. And for those who have hunger for material things, namely food, we do now have our lunch break, and we will be reconvening in an hour and 10 minutes, hour and 15 minutes latest to go on with our program in both channels. Lots of interesting things in store for you. As I say, we're branching out today, looking at the big picture, and we're going to be doing that even in the German language as well in Channel B this afternoon. So do return, and on your way to lunch, please sign that sponsors board. Remember, I asked you to do it. Well, now's your time. Head straight out to the board, put your signature there, and then go off to lunch. Good appetit. See you in a bit.